So, good evening, everyone. I'm Ayush, and tonight we gather not merely to hear a lecture, but to encounter a mind that has profoundly reshaped the very ways we think that about gender, power, and history. History, as Professor Indrani Chatterjee reminds us, is not only an archive of rulers and laws, it is also a living fabric of relationship, affections, obligations, and hierarchies. It breathes through the voices of those who seldom appear in state documents, yet whose labor and emotion sustain the worlds we seek to understand. Professor Chatterjee's scholarship compels us to look beyond the conventional binaries of the public and private, sacred and secular, ruler and ruled. In her landmark works such as Gender Slavery and Law in Colonial India and Forgotten Friends, Monks' Marriages and Memories from Northeast India, she has unearthed histories that were silenced not by accident but by design, histories of women, enslaved persons, and communities whose moral and emotional worlds challenge our modern assumption about freedom, family, and belonging. Her intellectual contribution lies not only in recovering those forgotten lives, but in asking us to rethink the very categories through which history is written. Whether interrogating the grammar of colonial law, the moral economies of kingship, or the gender circulation of wealth, Professor Chatterjee's work dissolved disciplinary boundaries. This evening, as he speaks on the theme Gender, Wealth, and Law in Indian History, Professor Chatterjee invites us to enter a world where wealth is not merely material but moral, where law is not merely institutional but intimate, and where gender is not simply an identity but a historical relationship of power and care. Her work reminds us that the archive itself is a terrain of struggle, a space where silence, speech, and structure converge. On behalf of the Voices from the Periphery, it's an extraordinary honor to welcome a professor and historian of rare billions whose scholarship has reimagined the relationship between the personal and political, the moral and material, the spoken and the unsaid. We welcome you with profound admiration and gratitude for teaching us that history, as its truest, is an act of care. Up to you, ma'am.
Thank you so much. That is such a warm and generous description of anything that I have done in these 40 years. I am truly grateful. If anything, could you please send me that write up? Because I've never had anyone praise me in such warm language and generosity. Thank you very much for this invitation as well as for that lovely introduction. And thank you to anyone else who's in the audience listening in. I'm genuinely touched and moved by this very, very elaborate introduction. Um, I have been struggling to think about wealth for a while now. And I thought for this talk,
Oh,
because it was, I was struggling with an idea that has been in my head and has been born out of a visit to Kolkata in the parts of Kolkata that many of you may not know, Chitpur Road, and so on. So let me begin with what I am thinking about. It was Golkoti, a Shia sort of establishment that is governed by the Waqf board now, but I was sent to it because of an encounter in the archives where a Khajasara in the Murshidabad household had left a will saying that there was this plot of land that he wanted to have dedicated for a religious event and building. And all the indications were that it was on Chitpur Road. So that's how I found Golkoti. No one amongst my peers knew it. I will land up there, but let me talk about why and how the process can be unfolded for of you. So, I have three goals for this talk. One was that I aim to extend or deepen the scholarship on gender that is already happening elsewhere historically by coming to it from the Islamic it. Now, as a term, articulated in English by feminist scholars in Europe and America, gender stands for particular codes of masculinity and femininity that each cultural political power uses to inscribe meanings to human embodiment and expressive communication. So, dress, gesture, everything counts as expressive communication. As many Persian and Urdu language histories of the Delhi, Hyderabad, Awadh courts between the 16th and the 19th century show us, many Khajasara who were biologically neutered were given names that were culturally coded as male. So, for instance, we have names like Etbar Ali Khan in Murshidabad, his chela Basant Ali Khan, Murshidabad again. I shall be talking about him, or Dayanat Ali in Awadh. All of these names are coded male, even though the people who bear those names and titles don't necessarily qualify as embodied males. So their very presence as men implied a different sex gender code in the Islamicate in British India, at least for the first half of the 19th century. Subsequently, they become identified with a much broader group called Hijra, but for the moment, let me just keep it to within the Islamicate. I'm referring, of course, to Marshall Hodgson's definition of a broader social cultural complex existing amongst the people who might themselves not practice the religious rituals of Muslims, but be shaped by many other aspects of a Persianate world. One can also safely say that in the context of Mughal and post Mughal Bengal, and certainly Eastern India, we are looking at a composite kind of political structure where many of the rituals and modes of thinking that are characterized as Hindu now were also taken on by the households of the Shias. We see this in the case of the boat festivals that we know happened in Murshidabad under the Nizamat, financed by the Nizamat. We know about Awadh, the Nawabs actually performing, especially Wajid Ali Shah, actually performing the Krishna Kanha uh, theater and the Kanha story as theater and dance. So I think in the context of the Islamicate, we have a very, very specific, very distinctive kind of experience in large parts of northern and eastern India in the first half of the 19th century. And the sex gender codes, therefore, were different from those that implied a correspondence between biological embodiment and cultural naming, increasingly consolidated in post Enlightenment European societies. In these latter societies, a biological female carried a female name, and a biological male a correspondingly male name. So the contrast between the two coding systems should be very significant for all of us. They have two implications. One, methodologically specific to an intersectional and transnational women's history in the future, that we have to allow for the possibility that not all the records bearing women's names refer to biologically female bodies, that there were likely neutered bodies in the same pasts that South Asian records are coding as female. This is also true given the early awareness of the Hijra, who presented as female in the drawings of, say, Solvins in Calcutta at the end of the 18th century. I just want to show you a little slide here. I hope this is visible to you. He actually, Solvins
No,
lives in
no, ma'am.
Calcutta.
The slides are not visible.
Is it
Can you please
visible?
share the screen? No, ma'am, no.
Um, how does one share the screen with you? I've not done this
Ma'am,
in a
just see there is a three dot, and in
three
beside of the three dot there is the option share screen.
three
There's a
dots.
desktop like sign.
I'm sorry, I don't see three dots on. Oh, here at the bottom. Okay. Um, it says I
No, the beside
cannot.
the three dots, there is a share screen option. It will be there.
Hang on a minute. Beside the three dots, there isn't a share screen option, over
Oh,
here.
then just click the three dots. I think it's there only then. Because in my laptop, in the beside of the three dots, there's a share screen option is there.
Okay, my Google doesn't have that, but uh, I'm really sorry, but I did have slides, but let's just then talk because, sorry, see, I'll tell you what I have here. Background and effects, full screen, adjust view, and so on. Background
No,
and
no, ma'am.
effects.
Mm, I think, ma'am, can you please share the slides with me
I
in
can send
between?
you the
So
slides.
yes, yes, then I can share it from my side.
All right, fine. I can do that. Wait. I'll have to go out and uh, send, open up my email and send
Yes,
stuff
ma'am.
to you. So it'll
Yes,
take a little while because I am on a
yes, ma'am.
university
Yeah.
email right over here. And so I apologize for this for to all the viewers here. I'm sure this is
No, no,
not how
it's, yeah, also sorry, my fault. Yeah.
we should have done a trial run, I guess.
Mhm.
But I am so short of time that I simply cannot make time for the. Oh no, it's not. Sorry, my machine is acting up.
So then, ma'am, can we just
Let's just carry on
go on
without
to
the
that? Yes, yes,
slides.
yes.
This is
Yeah.
really sad. Anyway, what can we do? Nothing else.
Yeah.
Okay.
Mm.
So, what I was trying to show you was that Solvens was aware and he had invited a hijra and drawn up a person who presented themselves at his house. And this person is coded female, completely wearing skirt and so on. So, if you weren't aware of the third gender as a possibility presenting as female, you would not be aware that they might carry female names. And that is something we need to be wondering about now as we look at visual sources, as we look at art history and sculpture differently for the projects that we write in the future. So, my second goal for this talk was to also study the ways in which such Khaja Sara, themselves slaves of their masters or mistresses' households, and therefore legally property of the owner, related to other parts of the same property. So, in this, I wished to probe the kind of dual nature of wealth and property as it came to be understood in the person of the slave, as well as the wealth that such a Khwaja Sara either created or managed. Though there is a vast scholarship on the slaves and slave born of the period between the 13th and the 18th centuries, especially now for the subcontinent, the historiography of slaves as wealth or slaves as property and the afterlives of the properties they managed or built or left behind Those have not been seriously discussed thus far in South Asian scholarship. Uh, or if they have been overwhelmed by a debate on private property in land in Mughal India that was set afoot by the concerns of visiting European observers in the 17th century. Of course, you all know this. The writings of Francois Bernier are especially prominent in this debate. In his letters to Colbert, the minister to Louis XIV, Bernier lamented the absence of private property in land in the Mughal Empire. And that's been the beginning of the debate for all subsequent Mughal historians. And he particularly referred to the operation of escheat, or the reversion of property to the state or a lord, as the sign of despotism or Oriental despotism. That's where Marx and others get their ideas from. In her 2023 essay on the 50 palaces, or Daulat Khanas, and formal gardens constructed or rebuilt during the tenure of Shah Jahan, the Mughal emperor, Eber Koch has surveyed all the examples of escheat recorded in both contemporary chronicles and elsewhere, and come to the conclusion that there was no standardized practice that could be traced in Mughal imperial annexations of these buildings and gardens. However, citing Athar Ali on the practices of the Caliphate towards the goods of its slaves, Koch went on to say that the Mughal Mansabdars had an honorary slave status, expressed in the phrase Bandagan-e Hazrat. While it expressed intimacy with the emperor, it also allowed the Mughal emperors to claim the houses and gardens of their military and administrative appointees, the Mansabdars. Curiously, however, one of the examples Koch gives to illustrate her argument was not that of a metaphorical, but of an actual slave. This was Jawahar Khan Khwaja Sara, who had created a garden during the tenure of the Emperor Jahangir. The emperor's son and successor, Shah Jahan, had taken this garden and bestowed it on his favorite daughter, Jahanara Begum. But on what basis? No one, not till the present as I'm speaking, has bothered to ask, because they're so convinced that the Mughal emperors were despotic and lawless. No one has bothered to ask about the kind of law or the permit, the legal remit of such an action. Apparently, because none of the Persian chroniclers themselves mentioned this legal basis on which this kind of practice could have been defended by contemporaries. That legal principle is actually wala. Most scholars of Arabic philology argue that the root is the Arabic va, la, lam, mim, in vav, lam, ye. So the Quran uses many permutations of this root to describe human relationships. As a historian of early Islam points out, va, lam, ye vocabularies changed in meaning between the early days of Islam and after the 9th century. In the early days, these vocabularies implied friendship, military support, treating others kindly, and maintaining family ties. By the 9th century, classical Sunni lawyers considered wala to be a form of kinship that permanently tied the freed person, that's the junior mawla or client, to the former master's family, senior mawla or patron, in semi permanent kind of relationships. The patron joined the group of people who bore responsibility for the crimes of the client, and in return, the patron had a right to inherit from his or her own client's estate. For the Shia, the additional provisions were that if the client had no surviving kin, then the ultimate patronat lay with the imam, the leader of the prayers. And the wala tie survived the death of both patron and client. And families of both the freedmen and the patrons were bound together in perpetuity. So, as the discussion from Koch makes clear, there is considerable vagueness about the claims of the owners of slaves to the property accumulated by such slaves. But part of the later historians' dilemmas also come from a twofold problem. One is ideological, the other is lexical. The ideological blinkers were set up by the sort of Atlantic model of slaves in plantations and mines. Such slaves never got to call anything their property, least of all other slaves. However, in the context of the broader Islamicate, it was often necessary for the socially secluded masters and mistresses to employ their personally owned slaves. You know, you have words for them in Arabic and Persian to undertake the arduous or dangerous aspects of trade and markets, such as travel. But a lexical reason, and the second reason for the later historians' silence, is the confusion that appears to have arisen from the Mughal period onwards, when the terms for slaves were replaced by other terms, especially those that overlapped with the semantics of devotion. And the word I can think of is chela, but also bhakt or bhaktin, bhaktan, so on. To give an illustration, Ali Anusheher has recently argued that along with Africans captured in raids and wars with Arabs, Gujarati merchants trading with the Persian Gulf ports in the 16th century brought numbers of captives of war from the Ottoman and Central Asian provinces back to ports of Western Asia, Western India, and from there they were sold, mortgaged, gifted, and transferred further. Those who entered the household of the Mughal Emperor Humayun included very young Turkic speakers. One of them spent at least 19 years carrying the king's drinking water. He's named Jauhar Aftabji. Jauhar's own narrative of Humayun reveals the presence of many other slaves, both working in the army as well as in the courtly household. When Humayun died suddenly, all these slaves were likely to have been inherited, along with his throne and estate, by his direct male heir, Akbar. And according to Abul Fazl, Akbar emancipated them and called them chelas or disciples thereafter. So, from the 17th century onwards, especially as the Mughal Empire began to organize and consolidate the Mansabdari Jagirdari system, the meanings of slave, freedman, free began to blur together in the hold all term Chela, especially with the establishment of this royal cult, the Deen-e Ilahi. So figures identified as Chela are, however, present in all manner of institutions in the Mughal histories, including in a group of artists in Jahangir's ateliers, studied by Yale Rice. If you go carefully through her work, you'll find the names cropping up. Perhaps the distinctions meant less to their employers than to those who inhabited each of these statuses, principally because of the assured operation of wala that no one else seems to identify. Perhaps, too, that is the reason for why a child purchased in the Deccan, educated and renamed Muhammad Hadi, was, after the death of his owner, attached by and to the revenue office, Diwani, of Mughal Berar. That's the person who then joins Aurangzeb's service, is appointed as Diwan of Hyderabad, Orissa, and eventually Bengal, and is titled Murshid Quli Khan, And we know that he moved his office from Dhaka to Maqsoodabad around 1703-4. By 1717, he was Naib Nazim. So the Nizamat of Bengal also begins with one such slave come chela, okay, of Aurangzeb. And this is certainly something we have to think about if we are going to think historically about wealth and gender in in a capacious way, because the records are telling us what many of us have passed off as very old history. The word chela continues to be used, however, for slaves in the Nizamat right from the early 18th century and right through to the end. So we have the Nazims of the early 19th century, lineal descendants of Mir Jafar, for instance, describing particular slaves as the ancient chelas and faithful servants of our house and so on. And in another letter, the Nazim directly equates the two terms when he writes, in the establishment of chelas who became slaves on condition of food and clothing, there can be no diminution. So even if we grant that masters and mistresses alone expected devoted loyalty from such slaves, equivalent to that of a spiritual teacher vis-a-vis their initiated disciple, we still need to place slave generated wealth at the heart of those histories of pre colonial property, wealth accumulation, and the legal histories of inheritance that followed in the subcontinent. This is necessary, and I'm going to do it here for post Diwani Bengal. For instance, because all my records are littered with one line statements, such as Babu Begum, the mother of the young Nawab Nazim Mubarak Uddaulah, authorized Mia Ambar, a eunuch in her service, Khwaja Sara, to buy revenue paying lands from the Zamindar of Nadia, that is Raja Ramkrishna. But such slaves were also given salaries in cash, permitted by their owners to work for wages elsewhere, and therefore to acquire property out of those earnings. So, what happened to those lands that they acquired or buildings that they sponsored when after their death? My attempt to answer this question is not to go back to what you have already referred to in the introduction. I'm not just trying to muddy the divide between private and public. I'm also trying to muddy the sort of sequestration of religion from the public. I've been trying to do this for a while now because I think we in South Asia have suffered deeply under this logic that religion doesn't belong in the public square, whereas all our lives we have seen and experienced the opposite. So I think we now need to theoretically challenge that as well. And this is one small attempt on my part to get there. So, what I'm therefore trying to talk about is the silence, the considerable silence in the company and colonial archives about Islamic laws that affected what happened to slave acquired wealth. Voila. Okay. By the late 18th century, the operation of Wala was so taken for granted by the slaves and ex slaves themselves that they tried to enlist the British officials on their side in order to evade the operation of the patrons' claims to their lifelong accumulations. For instance, British residents at the Shia Awadh court in the period between 1813 and 1818 had found that an older Muslim Khwaja Sara had tried to write a will to ensure that his Hindu nephews inherited his vast estate rather than the descendants of his deceased master. Of course, he did not succeed, but in the intervening years, many other records of the Khaja Sarai and the household's other slaves show us that this was, in fact, something that the slaves themselves were invested in. So I'm going to point to those other examples from Murshidabad. I will give you three instances when all the aspects of Wala were operationalized, even though the term was never mentioned. And this happened with the consent of the British officers of the company state. It appears that this counted as a hidden history of property and of the Islamic law of Wala that persisted till at least the end of the 19th century. And that's my third goal for this essay, would be to show the ways in which resistance to the operation of Wala came as much from erstwhile slaves as it came from those ordinary people who rented from them. And one of the earliest means by which the operation could be circumscribed, operation of Wala could be circumscribed, was by the establishment of a waqf. The waqf is a permanent endowment for religious or charitable purposes, as we all know, established by a Muslim. Usually, the founder of a waqf also named a trustee, known as a mutawali, to ensure that any income generated by the property so endowed was used for the designated charitable cause, such as a mosque, a school, a hospital. That's why the specially skilled and literate slaves of the Murshidabad Nizamat, such as the Khwaja Sara, began to write wills witnessed by British officials setting up Waqf. So, the entwined histories of Wala and Waqf might best begin with the eminent Khwaja Sara Basant Ali Khan. He was a slave, the head Nazir or superintendent of the matriarch of the Nizamat households in 18th century, Munni Begum. By 1813, he had served the household in various capacities for 35 years, suggesting that he had entered it somewhere around 1778 as a young person. By the time of his employer's death, he had served as her superintendent for 19 years. When asked what duties he fulfilled as a Nazir, Basant Ali Khan said that they were largely literary and even spiritual. He said he read the letters of the government to his mistress, i.e., he was literate, and he explained them to her. And then he gave orders for answers to other clerks who would write them. Then he sealed them, and after reading from the Quran to the Begum, he returned to his own home. By 1812, even as Munni Begum lay dying, the complete control of her dowry was acknowledged to lie with Basant Ali Khan and his two deputies, Bahar Afzoon and Mir Yusuf. So Basant Ali Khan had, there is a lot of discussion subsequently about whether Basant Ali Khan had come as a slave or come as a freedman, or whether he had come as a chela of the superintendent of the household earlier. That is, another Khwaja Sara named Etbar Ali Khan. In 1773, after the company's government deprived Etbar Ali Khan of all his cash allowances, the young Nazim had tried to compensate by gifting him a tax-free Lakhiraj hunting ground. Etbar duly constructed a mosque there and established a large stone within containing the sacred imprint of the footstep of the Prophet. These establishments are called Qadam Rasuls or Qadam Sharifs, well established in both Bengal and northern India from the end of the 13th century. But clearly, Etbar Ali Khan intended to construct a religious foundation and a waqf alongside. It's not that exceptional, merely because it was established by an erstwhile slave. It was done in the Deccan. Many of you know the instances of the Shiddis building these wonderful, beautiful religious establishments. After Etbar's death, the foundation was also managed by his chela, Basant Ali Khan, who also succeeded to the office of responsibility and authority, that is Mutawaliship. So when Muni Begum died, Basant Ali Khan was both Mutawali of a religious establishment and the Nazir of a Deori. Okay, those both those powers were combined in him. However, at this point, he was pensioned off and brought back again. He was given 350 rupees a month and told to go and just do his mutawaliship. But then the succeeding Begum, Amirun Nisa Begum, found she couldn't do without the knowledge that he had had and his administrative skills. So she rehired him and appointed him on a salary. So he had a pension and then he got a salary of 200 rupees per month. Basant appears to have used his salary and pension to further acquire titles in very profitable arable lands in districts of Bihar, such as Purnia and Bhagalpur, as well as in Bengal, in the Murshidabad district itself. And he built or acquired brick built buildings in the city. Quite a few of these buildings that he owned in the city were located near the Chowki. I wish my PowerPoints were working. I would have shown you where they were. One of these, described in a list of 1834 as a large dwelling house with Murg Khana attached, situated on tax exempt land, may well refer to the remnant of a building described in Rosie Llewellyn Jones's study as the eunuch's house. She described it as a two-story building, stylistically mid-18th century, with a flat front and so on. And the locals, even in 1980s, referred to that building as Murg Khana. Llewellyn Jones suggests that its 18th century function was that of a silk manufactory, a completely plausible suggestion given that the district itself was the epicenter of the trade in silk, yarn, and woven silks. Kasim Bazar, or Kashim Bazar as Bengalis call it, was a stone's throw away from that place. It was quite likely that the stalls on the ground floor had once upon a time contained copper urns heated by clay stoves, and the cocoons were steeped in hot water to loosen the silk thread. The central passage would have allowed the manager or owner of the manufactory to walk up and down in supervision. There is very good historical evidence to connect this building with silk manufacturing and Basant Ali Khan. That evidence comes from the innumerable quantities of Radhanagar and Kashim Bazar silk goods found in Munni Begum's household stores after her death. There were 160 pairs of long shawls, doshala they are called, upwards of 50 shawl handkerchiefs, 1,200 pieces of muslin, 300 pieces of linen, beautiful embroidered parda. Obviously, Basant had been directly involved in that cloth trade on behalf of the secluded matriarch. Even the agent in 1813 had suspected as much when he reported a local belief that Munni Begum had been involved in an extensive cloth trade. He confirmed that the actual trader was Basant Ali Khan, who traded in the name of Ba-Nam-E, okay, in the name of the Begum. And I just need to warn you that those of you who are working in revenue records of this period will know a lot about Benami. It's actually Ba-Nam-E, okay, in the name of the Begum. Therefore, there is nothing improbable in his also owning a building that functioned as a silk manufactory. It would well explain the high monetary evaluation put on this building in 1833 by his own clerical underlings. Yet, despite this suggestion of the Murg Khana in the 18th century and associated with Basant Ali Khan, subsequent British officials writing, and especially one civil surgeon in Murshidabad, who describes and identifies many buildings there, identified this particular building as the residence of Darab Ali Khan, an aged eunuch. This is very confusing. Who is or was Darab Ali Khan? And how did he come to be associated with a building which clearly suggests it was Basant Ali Khan's? Had the Nazims simply taken over one warehouse and given it to another? Had, in fact, something like Wala been in operation? This was, after all, secular property. One can try to answer this question by turning to the colonial records again and trying to see what happened in on the date that Basant Ali Khan died, 31st December 1833. He suffered from palsy, or maybe we would call it Parkinson's disease now. The symptoms can go both ways, but two different masters laid claim to the dead man's estate. One was the Nawab Nazim Humayun Shah, and the other was Amirun Nisa Begum, the contemporary matriarch and step grandmother of the ruling Nazim. Neither of their claims mentioned the word Wala, but each of them referred to clauses which operationalized the working of Wala in inheritance of wealth from a dead slave. Humayun Shah, that's the Nazim, pointed out that Basant Ali Khan was bought as a slave, he was poor, and he had had no property. But Munni Begum had made him Nazir of her household, having given him the property of Ethbar Ali Khan, her former Nazim. He became possessed of a deal of money during the time he belonged to the household and was the slave of Munni Begum. In other words, Basant had acquired his wealth in the Nizamat. And in this, he and his preceptor had both held high offices, requisite salaries, pensions. That was the ground of his claim. Moreover, he cited the precedent both for female ex-slaves and males when he referred to the fact that when Munni Begum died, her sons had predeceased her, her son rather had predeceased her, so there were no heirs. The agents of that time gave her estate to his uncle, Ali Shah, from whom he was lineally descended. So he stood to inherit Basant's estate on that ground as well. What he did not therefore explicitly say was that Munni Begum too had begun life as a purchased young girl in the household of Mir Jafar, the commander who had allied with the English in 1763. She had gone on to become a mother of Mir Jafar's child and therefore was no longer to be counted as a slave but as a Walid, that is, mother of a child, freed from future sales. And if Najmuddaulah had survived, he would have lineally succeeded to her estate, but he had not. And thus the inheritance to Munni Begum had gone to the brother of the original owner. I hope you can see that some kind of legal principle does show up in the way that the claims are being made. and therefore, the property of the Chelas should legally go to the Nazims. Amirun Nisa Begum, however, rested her claim to inherit as a patron on the fact that she had succeeded to the office held by Munni Begum, whose slave Basant was said to have been. She also argued that the dead man had been employed as a superintendent of her deori for the last 10 years of his life, so everything that he had should have gone to her. But Basant Ali Khan had also written 2 letters to the agent of the GG, that is AGG, agent of the Governor General, in those last months as he grew frailer. Remember, he was literate. One letter declared that he left the whole of his movable and immovable property in trust to 2 completely different members of the Nizamat household. One was Bahu Begum and her Khwaja Sara, Nazir of her deori, Bahar Ali, who was, in Basant's own letter, a brother chela in the time of Etabar Ali Khan. That is, they had come together up the ranks. They were to be appointed the Mutawwalis, superintendent of the endowment, directed to appropriate 2/3 of the income of the estate for the support of that Qadam Sharif, remember, that we've referred to earlier, and the Imam Bara situated in Begumganj. The remaining third portion of the income was to be expended on having Fatihas read for the funeral ceremonies, on enabling pilgrimages, and assisting the oppressed and feeding the poor. This was his will. Okay. It was clearly he was trying to set up a waqf, a religious charitable endowment. Therefore, the choice of a senior Khwaja Sara is important, as a Mutawwali revealed that something of the bonds that were important to these elderly dying ex or slaves as they were dying. For there were at least 17 other chelas and 93 other servants who worked for Basant Ali Khan before his death. There were another 37 servants and chelas connected with the Qadam Sharif. Though Basant's letter requested that both groups of slaves and servants should be maintained from the income of his estate, he did not authorize his own two chelas who lived with him to manage the estate. He chose his brother Chela and Bahu Begum. So, relationships of trust, of long association, that's what were important. Since the elderly Khwaja Sara had, however, requested the British agent to supervise, naturally, the agents came in. Their goals were, however, different. They were looking at the entire estate, especially after 1833, the abolition of the charter of trade of the company. They were looking at maximizing revenues, and they were therefore looking at all this landed estate in terms of taxability. And so Charles Metcalfe, Vice President of Council, chose to identify Basant as a free man who had a right to dispose of the property as he wished. And though this would continue to be the tenor of British officials, it rested on a juridical understanding of binary statuses, such as that of slave versus free. With the operation of wala, what you have is patron-client, not slave-free. And so the historically appropriate question that the officials of the 19th century never learned to ask was, whose slave had Basant been when he entered the service of Munni Begum in 1774? Was he Etbar Ali Khan's slave, or was he Munni Begum's slave? And since both were dead, did property in Basant, as well as to his acquired wealth, pass on to the heirs of previous mistresses and masters? But these questions were never asked. Instead, since, as I told you, the Charter Act of 1833 deprived the company of its monopoly, the company officials became focused on maximizing tax collection. Land that had been khas, personal property of the Nazims, but also increasingly now being defined as tax-paying land. Thus, the officer in charge of tax collection called for a statement of all the land holdings, and by 1837, we have a very vast list of lands in the name of Basant Ali Khan. It was at this point the agents who chose who was going to be the manager, and they chose Darab Ali Khan, the eunuch or the Nazir, Khwaja Sara of the current male Nazim, Humayun Shah. And that is how, by the mid 19th century or late 19th century, that entire set of houses and properties is identified with a man who had no connection with Basant Ali Khan, that is, Darab Ali Khan. Uh, the third part of this point I'll quickly make. What we have is by the late 19th century, many of the companies' goals in this region are to take back what were tax exempt lands. Many of these lands had already been given to tenants of different kinds. Some of the tenants belonged to the Kadam Sharif. They were cultivating those lands on behalf of the Kadam Sharif. Others were paying rent. Other lands, the tenant farmers were themselves paying uh, taxes to another local zamindar, and he was paying taxes and revenue to the company state. So there were lots of different sets of tenures associated with these lands. And it was because of this tax burden that many of the local tenants now began to push back when the fight between the company machinery on one hand and the Nazims on the other converged on the lands themselves. Under tenants of the Khwajasara managed estates were the most insecure of tenants in the Bengal countryside in the 19th century. A part of their insecurity may have arisen from the fact that they were themselves descendants of the very slaves and servants who had been attached to the buildings and lived off the income of these endowments. But such insecurity also extended to men who were not descended from the slaves or chelas of the households. Such undertenants included literate groups such as the Quran readers and caretakers of the mosques and masjids, as well as the illiterate groups such as cultivators and semi literate groups such as shopkeepers who had been set up as part of the Waqf to provide income for a particular religious and charitable purpose. All these undertenants' insecurity became visible in around the late 19th century. So, this is when they began to petition. In June 1896, some of these Shia men of Murshidabad began to petition the lieutenant governor of Bengal that such a handover of lands that they had cultivated and were attached to the Kadam Sharif would be a violation of Basant Ali Khan's will. The memorialists believed that Nawab Bahadur had set up, that is, the Nazim of Murshidabad, had set up his claim to the trusteeship of the endowment by virtue of a custom which he held to be prevalent in his family. This custom, and the Shia literate men are actually aware of it, this custom was that all properties left by the family eunuchs pass on their death to their masters or to their descendants who survive them. What the Shia memorialists were calling custom, I argue, was actually Islamic wala, that they were not naming as wala, but as custom. In this, they were actually um, quite right in saying that it had become the custom, but what they weren't actually telling you was how convoluted the whole process was, in that Basant Ali Khan's own will was never actually followed. So, in conclusion, what do we learn from this brief story? We learn that colonial officials, by suppressing all mention of Islamic laws of inheritance from slaves, had indeed emboldened a patriarchal presumption in all male Nazims to inherit not just from the Khwaja Sara, but from also all the dead females, even when they were free women. So, not just Munni Begum, but also the wealth and inheritance and estates attached to free women who had been married into the Nizamat, such as Amirun Nisa Begum, such as Bahu Begum. All of these women's wealth was also given to the Nazim by the British. Was this just another case of colonial misogyny, or was this give and take between a male Nazim on one hand and a male AGG on the other. We can always debate this, especially because it was all happening at a moment when anti colonial forces were gathering force on the ground. So, with that, I will come to a stop and hope that we can talk some more about these issues I've raised. Thank you.
Thank you so much, Professor Chatterjee, for that truly illuminating and thought-provoking lecture. Your words have not only deepened our understanding of how gender, wealth, and law intersect, I can say, in Indian history, but have also reminded us how history itself must be reimagined through the textures of intimacy, power, and moral exchange.
Mm.
We are deeply grateful for the intellectual generosity you have shared with us this evening. Now, we would like to open the floor for questions and reflections. I invite everyone to engage with Professor Chatterjee's ideas, to respond to questions, and to continue this vibrant dialogue that her lectures has so powerfully begun. So, ma'am, can we begin the Q&A session?
Sure, please do.
So, we have so many questions on YouTube also. So, if anyone has any question, they can also write in the chat box. I can also read out for ma'am. But
Sure.
before, I will just take one question from our YouTube.
Mm-hmm.
It's asked by Pallab Vaidagya.
Mm-hmm.
He's asking that if we consider law, in quote, as a language of power, how can historians read the silences within that language to recover the lives of those excluded from it, particularly women and this kind of eunuchs and servants?
Yes, a very good, very profound, large question. Okay. So, my argument is that for the context of South Asia as a whole, or say the Indian subcontinent, we should allow for multiple layers of what we would call legality or law. One is in the nature of the settlement of the Indian subcontinent, there are many different groups living and working together. Instead of a single law, which comes about with the IPC, for instance, and that IPC is the result of many different kinds of legal and social political processes. We don't have a standardized law as such in the period that I'm thinking of or working in the latter half of the 18th century. So we should be making sure about which region we are working on, which kind of group and sort of social structure we are trying to excavate, and keeping all of those in mind, who is a sort of who's setting the terms and how are they being explicated. What I have told you about is how the very principle of Islamic law, wala, is actually operationalized but never articulated. It's never claimed as a legal principle, right? Not by the Persian chroniclers, not by anyone till 1872, when there's a court case in Bombay in the context of the inheritance from the Nawabs of Surat, and that split between his concubine widow and his sort of lineally descended, endogamously married lineage, a woman from that lineage. That, raises the issue, where was Wala all this time? So, what I have told you about is how, in fact, no one is talking about legal principles at all. Law or legal principles, especially from the Islamic corpus, go missing in the colonial archive, even though they have said that they are going to follow Islamic law. Remember, That's the um, guarantee that Warren Hastings gave in 1771-72, that the law of the Hindus in matters of succession, inheritance, marriage, and divorce shall be the law of the Hindus in those matters, and the law of the Muslims will govern matters of inheritance, marriage, divorce, etc. So, in effective terms, this was the guarantee. So, they should have been actually finding what the Islamic law was when it came to wala, but they didn't. So, there is a lot of silence on many fronts. And we as historians have to do a lot of background research and informing ourselves in order to be able to track what we read in the archives. I hope that answers your question.
Yes, ma'am.
Okay.
So we'll take the next question from our YouTube. It's asked by Rakhi Mondal. She's asking that in studying gender and law, how do we avoid reproducing the same categories that colonial or patriarchal systems used to define and control women's identities?
Huh. That's a lifelong task. You have to take a vow to do that. I run courses in my university called Decolonizing Gender. And they're always very, very unpopular because who wants to go up against the establishment? But there are two or three people who come along, and my way of doing it is always beginning the process from somewhere else. You cannot, absolutely cannot decolonize gender in any shape or form by doing it from within the system that the records are created from. You can only do that from outside. And so you have to spend some time training yourself to either read in what I am calling the Islamic it, think, equip yourself, give yourself bigger models, bigger conceptual ideas, or just simply different histories. So either read in Buddhism or read in Sufi texts, Sufi law. The pre-colonial must be taken seriously, and the world emerges differently. It won't happen overnight. It has not happened overnight for me. I began, like you, Rakhi, inside the system. I began also inside JNU, inside, I'm going to write the history of women. And my first piece of work was actually a horrible piece of work that I completely am embarrassed and ashamed of. But it taught me that I could not take any records at face value, even if they were in Bangla, written by women, published from sort of anti-colonial presses. I could not take any of that as given because they were not making sense to me. That was how I began to understand that I could not tell the history of women from within vernacular records either, because vernacular records created in the 20th century or late 19th century were also created within a colonial matrix. They were also trying to achieve some sort of notion of bhadroness or something, and rewriting domesticity in a particular way, and recalibrating different aspects. And it simply didn't seem to be adequate to the work that was needed for South Asia in terms of decolonizing gender. And that's why I went backwards in time. I trained myself in Persian, learned to read Urdu, and read with my Gurujis in Kolkata, my ustads, and then began to think backwards. So you have to do the work in order to uh, reconceptualize gender differently. I've just given you an example of why we shouldn't fall for the sex gender codes of the post enlightened European world. There has been a lot of work on manliness by Rosalind O'Hanlon, on masculinity by Minnie Sinha, Hinchy's work on the Hijra. Already, all that work has happened. I think we need to be thinking from and with that scholarship outwards. I hope that makes sense.
Thank you, ma'am. In the Gmeet also, if anyone has any question, they can also unmute themselves and ask. Otherwise, I will take another question from our YouTube.
Sure.
It's asked by Udisha, and he's asking that in your research, do you think women's roles as custodians of wealth, emotional, social, or material, were recognized or erased by legal systems by any means?
Uh, this is something I'm struggling with. It's a very important question. And I think you should absolutely keep asking it and trying to find answers. My answer will be specific to time, group, and place. So, you asked Udisha whether women's authority as custodians, as managers of wealth, was recognized. I think it was recognized in the pre colonial, pre 1790 phase. What happened subsequently, and I've published on this, you can look up all my work on academia edu or write to me and I'll send you my published work. It's that from 1790 we've begin to find, because of the permanent settlement, a kind of smuggling in of the idea of kavacha. That is, in common law, in Britain, that is, married women were not supposed to manage any wealth independently. They were covered, or responsibility for them was covered by the men they were married to. And of course, there's a very fantastic scholarship on coverture in Britain and how that was evaded by families with daughters. But what happened with the men from Britain coming and forming policy in India was that they operated with coverture as a taken for granted. And so, in some of the documents that I've seen from post 1790 period, they actually say women, that's a married woman, how is she signing off on the estate and so on. So they're actually trying to, get women's authority de-recognized or delegitimated. What happens is that in the next phase, women's authority to inherit, not just manage, comes under attack. That goes to the courts. And from there, we find in the Sadar Diwani Adalat records that's a tremendous contest, partly because, let's face it, all of the women are also equally embattled within their households and families. And so there are always, second cousins, uncles of the dead man or somebody who also claims a stake in that estate and does not want the woman to have it. So family dynamics, household dynamics, kinship contests are fundamental to how the women begin to try to fight back and begin to lose. And it's not a one and done deal dramatically or overnight, it's a gradual creep that is the result of both policy, land tax policies, as well as legal encroachments on how to define this or that. And here, Rachel Sturman's work on the governance of the household shows us how the Bombay judges, for instance, began to even dictate what kind of marriage should be standard in and amongst Hindus, and what is required for Muslims. We begin to find all of that. So there's clearly a reshaping through law and legal judgments coming down from on high on how bhadraness or respectability or middle classness must be organized, where women bear the brunt of that kind of redefinition. So it's not any one moment, but how the process gradually unfolds. I hope I've answered your question, Odisha.
Yes, ma'am. Uh, we'll take another question. It's
Sure.
also asked by Krishna. We have so many questions left here, but because of the time constraints, we only have to take one or two more.
Look, if there are questions, you can send them to me with the names of the people attached. I will try and answer them individually as and when I get time by email. Okay. I don't want anyone to feel that I don't take questions. I do. I am here on a Sunday uh, to be able to talk with all of you. So it's important
Yes,
that we
ma'am.
talk.
I will give you all the questions.
Yeah.
But now I'm just taking one question. It's asked by Krishna.
Okay.
She's asking that many colonial laws claim to bring in court justice or in court reform. In your view, how did these legal interventions reshape existing hierarchies rather than dismantle them?
That's all the historians coming out of my generation have all talked about this. You can begin by reading Radhika Singha's work, The Despotism of Law. Okay, she has established how, in fact, a kind of despotism is established by law in terms of criminal justice, in terms of reform of marriage, etc. All the historians, Janaki Nair and onwards, have told us how complicated this is. I mean, this is not just Janaki, Amrit Srinivasan's early work on the Devadasi Reform Act of 1947, Devesh Sonaji's work. All of that work is now published and available for all of you. It shows us that they're actually completely reconstituting hierarchies, but in different ways. Okay, I have been looking and I've been teaching on how various groups are identified as tribals or adivasis, or to make them into coolies and for indenture, being exported out of the country altogether or exported to Assam plantations. Um, I would say that it just depends upon which particular law you're looking at, which particular area of reform you're looking at. Marriage reform has been severely criticized by the most junior scholars that are coming out of studying. I'm thinking of Pandey's work, Ishita Pandey's work on the Age of Consent Bill 1891. There's a tremendous amount of work now. So, just punch in reform and you'll see what exactly is happening. But I don't think colonial laws actually they reshape hierarchy to suit particular kinds of purposes. Their goal is taxation and maximization of an economic model, right? That should never be lost sight of. So it's sort of the making of dominant castes, for instance, the making of groups that are, that are called Dalit today, but remaking them in terms of labor worthy groups, right? That's all happening in this period. And in the period that you can actually now trace through the records of the colonial archives itself.
Yes, ma'am. We'll take the last question for this session. Is
Okay.
asked by PRE. Is asking that, in your view, what is the greatest danger when modern historians interpret pre-colonial or colonial gender relations through contemporary legal or feminist frameworks?
What is the greatest danger? Okay. The greatest danger when modern historians begin reinterpreting is the danger of the present, what is called teleology. You know, it's the notion that who we are is the best and the end point of all development, all evolution, and everything else before us is sort of bad and different versions or degrees of primitiveness. That's the greatest danger. Precisely because that allows us to be uneducated and remain uninformed, both linguistically but also epistemologically, about the conditions of the past. For instance, it's only when you begin to learn, and I say this now loud and clear, you only when you begin to learn different languages and the different genres of their writing, and you see the tussles and contests within any one epistemic frame, that you can actually locate what you are curious about in those debates. And you can then come from there. Instead of which, we have somehow inherited, and I'm saying this with all due humility, we have inherited this notion that somehow the colonial model of the gender sex divide, and the one that we were trained into or socialized into was somehow the best, and everything else has to catch up with us. I think that's colonial arrogance replayed, where you have a system of the Khwaja and so on, who are both slave and masters at the same time, who are both propertied and using the best of Islamic laws of religion, waqf making, to resist their own masters. I think you're required to think differently from how you've been taught to think about, oh, those poor, silly people, right? Who don't know their gender history very well, or, they're not doing vote counting, etc., etc. I'm therefore extremely suspicious of modern scholars who are doing history only to pass judgment. If you're doing history at all, do it with some integrity, or don't do it at all. No one gives any, has anything for any respect for scholars like me, who are not rushing in for public fame or anything else other than getting the story somewhat right. That's all I'm in the business for. So if you need other things in your life, don't become a historian. It's all my advice.
Hmm. So, thank you, Professor, for your profoundly illuminating and deeply moving lecture and the question and answering sessions. Your reflection on gender wealth and law in Indian history has taken us beyond the conventional boundaries of scholarship into a space where the personal meets the political and where emotion and economy, affection and authority come together to tell a far more intricate story of our past.
Yeah.
We have reminded us that the history is not merely about power as recorded in the statues or statecraft or archives, but also about the invisible networks of care, obligations, and moral exchange that
Mhm.
shapes human life.
Yeah.
Through your words, we have glimpsed how the texture of law is kind of, woven with the threads of gendered experience, and how wealth itself, so often measured in numbers, can carry the weight of intimacy, insight, and
Yeah.
memory.
Yeah.
On behalf of Voices from the Periphery, we extend our deepest gratitude for your generosity, your brilliance, and your courage to continually expanding the horizons of historical thought. Your presence among us tonight has been an immense privilege, pleasure, a reminder of how history, uh, when told with such sensitivity and integrity, can illuminate not only the past we inherit, but also the futures we must imagine. Thank you, Professor, for inspiring us to think, to rethink critically, to listen more compassionately, and to remember more truthfully. Thank you, ma'am.
Thank you so much. As I
Thank
said,
you.
please send me these wonderful questions as well as your
Hmm.
great comments on my work. I will frame them and put them up as a certificate to myself that I should keep going, because sometimes it becomes very hard to keep going in the face of so much of opposition and neglect. So thank you.
Thank you, ma'am. Thank you.
Thank you.